Subscribe to our channel and hit the bell icon so that you know when live we go. Hello and welcome to RAU'S IAS DNS session. We are going to have a discussion on today's newspaper, The Hindu, Delhi edition, dated 20th September 2022. We shall pick up only those articles which are relevant for civil service examination and will discuss them as per the demand of the exam. This is the lead article from page number 6, the hijab case and the essential practices doctrine. You must be very well aware that Supreme Court of India is presently hearing arguments on the correctness of the Karnataka High Court judgment. The judgment that upheld the ban on the use of hijab by students in Karnataka. And the petitioners, they have raised many questions concerning the rights of students to freedom of expression, freedom of conscience, freedom of religion, and the impact of the ban on the education of Muslim girls and women. The article suggests that when such issues come to the court, there are doctrines of the constitutional law in the hands of the judges to decide on the cases. One such foundational law that the Constitution provides is the right to freedom of religion under Article 25. But however, right in the beginning of Article 25, there are certain restrictions. There are restrictions of public order, morality, and health. But that's not all. The article also says, and to the other provisions of this part, meaning if the right to freedom of religion comes in conflict with other parts of fundamental rights, then that can be considered as a restricting point for exercise of this right if the Supreme Court decides so. And over the period of time, this fourth open-ended criteria in Article 25 itself has paved the way for a doctrine called as the Doctrine of Essential Religious Practice. Doctrine, whatever you feel comfortable with. In our discussion here, we'll focus on the Doctrine of Essential Religious Practice. But before we do so, I'll quickly summarize the observation of Karnataka High Court in the hijab case. First of all, the court has opined that hijab is not an essential religious practice of Islam, thus the right to freedom of religion was not violated. So the ban on wearing hijab in the classroom by the school management is not violative of Article 25. The court also ruled, and this is a big legal question in front of Supreme Court right now, the court ruled that there exists no substantive right to freedom of expression or privacy inside a classroom. Therefore, these rights were simply not at stake here. The High Court believes that the classroom are qualified public spaces, and at such public places, the individual rights must give way to the interest of general discipline and decorum. And hence, the directive of school management is not violative of Article 19 either. High Court also said that the ban did not stem directly out of government's order. The notification given by the ministry only asked for uniform dress code. The dress code in this case was prescribed by school management committee. Hence, the rules, regulation, the laws made by the state has not been discriminatory against any community, caste, or any other grouping. So the order is not violative of Article 14 as well. Further, the High Court also asserted on fundamental duty under Article 51A(h), which is about promoting scientific temper and developing spirit of inquiry. There is one mute point in the judgment of the Karnataka High Court on which the Supreme Court will have to make an observation at least orally, and the point is this. The High Court has said that right to conscience and right to practice of religion, these two are mutually exclusive. There are many legal questions in this judgment. We'll try to do our best to discuss as many things as we can, and we'll discuss only so much as is required, because the issue is still sub judice, and our final opinion for the purpose of exam must be formed after the judgment from the Supreme Court has come. So first thing first, what is essential religious practice? The Essential Practices Doctrine, it owes its existence to a speech made by Dr. B.R. Ambedkar in the Constituent Assembly. He said that the religious conceptions in this country are so vast that they cover every aspect of life from birth to death. He further said, I do not think it is possible to accept a position of that sort. we ought to strive hereafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with the ceremonials which are essentially religious. It is not necessary that laws relating to tenancy or laws relating to succession should be governed by religion. Here, Dr. Ambedkar was striving to distinguish the religious from the secular by arguing that the state should be allowed to intervene in matters that are connected to religion but are not intrinsically religious. The phrase that Dr. Ambedkar used was essentially religious. The intention here was to distinguish between religious and things which are secular, like the issues of succession, tenancy, etc. But over the years, Supreme Court has evolved a practice test of sort to determine what religious practice can be constitutionally protected and what can be ignored. And the first judgment in this regard came in 1954. Here, Supreme Court held in Shishur Mutt case. This case came to the Supreme Court with regard to management of this mutt that was in Udupi. In Shirur Mutt case, Supreme Court ruled that the term religion will cover all religious and practices integral to a religion. And the test to determine what is integral to a religion is called as Essential Religious Practices Test. So far, Supreme Court judgment was in line with the stand that Dr. B.R. Ambedkar took in the Constituent Assembly. The purpose was to draw a line between religious and secular. The test was not meant to distinguish between practices that were essential to a religion and those that were not. That was not the opinion of B.R. Ambedkar, and that was not the opinion of Supreme Court in Shirur Mutt case either. The purpose so far was to distinguish between practices that were essentially religious and those that were secular. Like management of tenancy is not a religious practice. It's mostly secular practice concerning the administration of the day. So the idea was that the secular practices, they can be restricted or regulated by law, and religious practices cannot be meddled up with the law. So over the period of time, the concept of essentially religious transformed into essential religious practices. This is in the theological realm. You have to have good idea of the scriptures and conventions, and you have to read the commentaries of religion to understand what is essential religious practice of a religion. But you do not have to go into the theology to understand what is religious and what is secular practice, what concerns day-to-day administration and what concerns the core religious thing. But gradually, judiciary through various judgments have concretized on this idea of essential religious practices test. Allahabad High Court has in 1957 ruled that bigamy cannot be considered an integral part of the Hindu religion. In 2004, Supreme Court ruled that Tandav dance was not an essential rite of Ananda Marg faith, because Ananda Marg faith germinated in 1955 and Tandav dance by this faith was adopted in 1965. Supreme Court here was giving judgment on their right to perform Tandav dance on streets on the ground of Article 25. But when Tandav dance was declared to be not the essential practice of the faith, then regulating or restricting its performance on street is no more violative of Article 25. Similarly, in 2016, the Bombay High Court permitted women to enter the sanctum sanctorum of Haji Ali Dargah. In this judgment, Bombay High Court said that the trust of Haji Ali Dargah has failed to place any material on record to demonstrate that the exclusion of women from dargahs was an essential feature of Islam. The same doctrine was used in 2017 by the Supreme Court to give judgment on triple talaq. And the same doctrine was yet again used in the Sabrimala judgment by Supreme Court to reject the claims of Ayyapans, the devotees of Lord Ayyappa, their claim that the exclusion of women between age of 10 and 50 from entering the temple constituted an essential practice. You understand that the fundamental rights are fundamental, they cannot be violated. But this doctrine has been used by the Supreme Court to give ruling without violating the fundamental right. Because in the fundamental right under Article 25, they have made it clear
that religion will cover only what is integral to the religion. So something that has been declared not to be part of essential religious practice will not amount to violation of Article 25. So this doctrine brings along lots of benefits. It has ensured balance between different fundamental rights. For example, in the Sabrimala case, Supreme Court struck a balance between two fundamental rights, right to equality and the right to freedom of religion. So Article 25 was balanced with Article 14. This doctrine has also ensured social justice during the practice of right to freedom of religion. Social justice with regard to marginal groups like LGBT community, transgenders, women. Around 2017-18, Supreme Court gave a definition of constitutional morality as well. And through application of essential religious practice doctrine, Supreme Court has given constitutional morality primacy over religious morality. For instance, in the case of striking down Section 377, the constitutional doctrine of rule of law, this also gains primacy over rule of religion. But fundamentally, what it also does, it protects the essential practices of religion. If something is not the essential practice of religion, we can forego it to give importance to other fundamental rights, for the cause of social justice, to implement social morality, for rule of law. But if something is essentially part of the religion, religious practices, then it cannot be touched by the state. So although this doctrine helps in compromising other things for the greater good, but on the flip side, it also protects the essential practices from the interference of state. But there has been many concerns that has been raised regarding essential religious practices doctrine. One of it we have talked about. In the original Supreme Court judgment of 1954, the court did not lay down this doctrine. And the initial practice was to draw a line between something which is religious and things which are secular. Supreme Court did not delve into the theology of declaring what is essential practice and what is not. So what has happened is that the court has narrowed down the extent of safeguards available to religious customs. Because what should happen ideally is that the practitioners of the religion, they themselves must decide what is valuable to them, what is integral to their culture, to their practice, to their religion. But rather than that, the court now decides for them. And if you look at it from the other lens, because it protects certain things, if that can be categorized as essential religious practice, then you can't change it. That means any progressive legislation that will have to negate some of the essential practices, that cannot be brought about, even if the effect of that is the cause of social justice. Because things which are not essential religious practice, they can be compromised with. But if things are essential religious practice, then that's the end of road for the state. State cannot interfere in those matters. The problem with use of this doctrine is that judges, they do not have the religious theological competence. They are not well versed with the scriptures and traditions and cultures and commentaries. They do not actually know what is essential religious or not. They largely go with things that they generally see to be practiced or by their instinct. But that fundamentally is wrong. Essential religious practice comes from religious tenet, whether the followers practice it or not, regardless of that. And to strictly judge what is integral to the religious tenet, you have to be competent in knowing that religion. And judges are not. And there are no parameters laid down to decide the essential practice. Sometimes they rely on religious text, sometimes they rely on the empirical behavior of followers, sometimes they rely on certain opinion of certain experts, ignoring the opinion of others. So what has been recommended by certain legal experts is to adopt a different doctrine when cases like this come up. One such principle is the principle of anti-exclusion. Because essential religious practices requires the competence in the theology, in the religion, which judges don't hold. But judges holds other competence. And using the competence that they hold can be applied very well. And it works. And it may even work better. In the Sabrimala judgment, Justice D.Y. Chandrachud, he proposed this doctrine. And now it is called as principle of anti-exclusion. It was first proposed by him. Its application would require the court to presume that a practice asserted by a religious group is in fact essential to the proponents of its faith. So under this doctrine, who decides what is essentially religious? The proponents of the faith, they themselves decided. But regardless of such grounding, the Constitution will not offer any protection to any practice that excludes people on grounds of caste, gender, or other discriminatory criteria. And this can be handled by judges very well. This doctrine proposed by Justice D.Y. Chanchur allows for due deference, meaning regard, respect, to the ability of a religion to determine its own religious tenets and doctrines. And that's how it should be. Judges shouldn't be deciding what is essentially religious and what is not. But at the same time, the anti-exclusion principle postulates that where a religious practice causes the exclusion of individuals in a manner which impairs their dignity or it hampers their access to basic goods, the freedom of religion must give way to the overarching values of a liberal constitution. And it was that time during Sabrimala judgment and Triple Talaq judgment and others where Supreme Court was asserting for constitutional morality. Supreme Court also observed then that the individual rights cannot be violated for the demand of social conformity. So you can also observe that this principle of anti-exclusion can be applied on individuals as well. But the doctrine of essential religious practice that mostly is applied on a group. Now we will come back to the observations made by Karnataka High Court that we saw in the beginning of the discussion. One of the issue there was essential religious practice. We have seen the benefits that it brings. We also have seen the problem of essential religious practice. Now it is up to the wisdom of Supreme Court whether to apply this doctrine in the given case or not. The legal opinion that is floating around is also that Supreme Court, rather than touching essential religious practice, should make this point more clear, that does the fundamental right extends to classrooms or not? Are classrooms qualified public spaces? Are they at par with the army or the bar council? The question is that there is a dress code for lawyers, but lawyers, apart from adopting the dress code, can they use something on top of that, like a pagdi, or a mala, or a tilak, or a kada? Supreme Court threw some light on the issue of general discipline and decorum. Can there be a harmony between this and the fundamental right of freedom of expression? The High Court judgment has asserted on fundamental duty under Article 51A(h), promotion of scientific temper and the spirit of inquiry, but it has ignored Article 51A(f), which speaks of preserving composite culture. There is also a very strong opinion that right to conscience is not mutually exclusive to right to freedom of religion, because both the rights have been guaranteed by the Constitution. In your analytical study of the issue, you should also think of a dimension that is not generally touched by the newspaper. But indeed, there is a legal opinion connecting this issue with the Puttaswamy judgment. Freedom of expression and the way you dress up, that concerns your privacy and your dignity apart from the right to practice the religion. In the Puttaswamy judgment, it was held that choice of appearance, it is an aspect of privacy. In the Puttaswamy judgment, Supreme Court made a very important remark. It said validity of the States Act must be seen not on the basis of objective, but on the impact of the state's law. Objective here is secularism, but the impact here is exclusion of these Muslim girls and women because right to education is being denied. Puttaswamy judgment also stressed on the decisional autonomy and the way a lady wants to keep her appearance, that's her decisional autonomy. So the judgment can be based on Puttaswamy judgment. There is also an alternative doctrine that Justice D.Y. Chanchur, the next in line Chief Justice of India, he has proposed. There is also an opinion where Supreme Court must make it clear whether the fundamental right extends to classrooms or not. So judgment can be based on these grounds as well without getting into essential religious practice because there is problem in practically implementing it. These are the dimensions around the issue. The final conclusion we will draw only after the judgment has come. This is the article from the text and the context section, Scandinavian Social Democracy. See, historically speaking, socialism has been seen as somewhat in the halfway between capitalism and communism. And in this spectrum, if we see, democratic socialism fits somewhere in between capitalism and socialism. And social democracy will fall somewhere between capitalism and democratic socialism. So here we are for this topic. This bandwidth in this spectrum will represent social democracy. Capitalism is all about letting the free market generate unlimited profit for corporations and individuals. But the downside of capitalism is that when it's unregulated, this leads to things like child labor, contaminated air and water, environmental degradation, resource depletion, and the concentration of wealth in the hands of very few. And communism is about creating a classless society with absolute equality, with the government dictating the price, supply, and distribution of goods and services. But the downside of communism is that the only practical way of redistributing wealth with absolute equality is by force. So these governments with communism, they usually end up becoming authoritarian regime. So the sweet spot of socialism arose as an attempt to merge the best of capitalism and the best of communism. The traditional definition of socialism basically says that there should be some free market system to determine the supply and demand of the products. But the government should own the country's major industries so that the people can benefit from most of the wealth. But there is a downside of socialism too. The downside of socialism is that it's very vulnerable to corruption. If the people running the traditional socialist system are corrupt, then these type of socialist government will also bend towards authoritarianism. And institutional corruption in socialist countries are very common. The democratic socialists, they still believe in social ownership of major industries either through the government or through the worker alliances. But they reject two main aspects of traditional socialism. One is that they sharply reject any authoritarian system. And two, they reject the Soviet style planned economies where the government determined the prices and supply of goods. There's a lot of debate about what exactly democratic socialism entails. But in essence, democratic socialists believe that workers should enjoy a larger share of profits because these workers are helping the economy to grow, helping the goods to get generated. They also believe that strong social safety nets are essential for the stability and long term growth of society. And it's very interesting, you must be reading about him in the newspaper. America's most famous self described democratic socialist, Bernie Sanders. He is opposed to the idea that the government should own the country's major industries, meaning the government should not control the means of production. But he also promotes an increase in minimum wage, medical care for all, free college education for all. And if you analyze, these policies are in line with the Nordic countries. Nordic countries call themselves social democracy. When you increase the safety net, you make the social security measures really strong and yet keep the economy open, then you move towards social democracy. Social democracies are basically the capitalist system with really strong social safety. Social democracies, they are based on three fundamental values: freedom, justice, and solidarity. Sometimes in some other literature, you can find alternative values mentioned in the list of the three fundamental values for social democracy. Instead of freedom, you might find the mention of liberty. And instead of solidarity, you might find the mention of fraternity. Freedom means that every individual should be able to decide how he or she will live. And the state and society should not interfere arbitrarily. There must be ample financial security, educational and social opportunity. And every individual can live this freedom actively. There are various concepts of justice that you must have studied as part of your GS. Justice generally means, in the eyes of the law, everyone is equal, irrespective of where he or she comes from, irrespective of the background, irrespective of the sex. But not only that, justice also means that given the same opportunities, people's achievements and requirements are taken into account. That is why instead of freedom, you'll find mention of liberty somewhere, and instead of justice, you'll find the mention of equality. Solidarity is about everyone being willing to help each other. Solidarity or fraternity is the glue which holds the society together. If we talk in terms of liberty, equality, and fraternity, because you are familiar with these terms as part of preamble to the Indian Constitution. All these three must work in concurrence and in union with each other. In a scenario where we have liberty, we have equality, but we don't have fraternity, this invariably will lead to a police state. Fighting for each other's rights, filing PIL in the Supreme Court on behalf of others, participating in socially important movements, filing RTI to help others, those are extremely important. Otherwise, police state, authoritarian state is the end we are moving towards. In the scenario where there is equality and fraternity, but there is no liberty, when there is no liberty, there will be no individual innovation. In the scenario where there is liberty and fraternity, but there is no equality, in that case, we will have an elitist state where the elites will be in control of power. So we understand that all three of them must operate together to make the system efficient and just. However, these values are essential but not sufficient for the society to be able to live in harmony. This is why social democracies are also based on human rights conventions. The two human rights conventions of United Nations, they are explicitly the part of social democracy. If you talk about freedom or liberty, there are two concepts of them. One is termed as negative civil rights and liberties, and the other as positive civil rights and liberties. The negative civil rights and liberties are protective rights, which protects interference of a state or communities or society in the life of individuals. The positive liberties makes it possible for one to be able to practice his or her civil rights and liberties. In any social democracy, both positive and negative civil rights and liberties, they are taken very seriously. Without the positive ones, many people won't have access to negative ones either. Negative civil liberties can also be considered as the minimalist approach. That there will be certain rights and liberties to individuals which society and the state cannot take away. Like, for example, right to life. But the positive liberties ensure that the individuals can actively exercise the right. It has to do with capability and opportunity of individuals. For example, let's consider a negative liberty, freedom of expression. One has to speak, one has to express oneself, one's mind freely. But to be able to practice this right, one must have the opportunity to develop his or her opinion. This is why education is important. That is a positive liberty. So, this positive liberty will ensure the negative liberty of freedom of expression. But education of individuals are financed by all citizens by means of taxes. In other words, those taxes amounts to small infringement in the rights to own property. That's again a negative liberty. So here, right to property, a little bit of infringement on that will ensure education for all. That in turn will ensure freedom of expression. So negative liberties and positive liberties are intricately linked with each other, and in any social democracy, both of them are taken very seriously. If we talk about the relation of economics with social democracy, we must understand that this relation, the relation that the state and the market economy must have, this has made a lot of brains to think and ponder. In the mid 18th century, Adam Smith believed that the state and the market should be strictly separated. The invisible hand of the market will best provide for everyone. But during the industrialization of the 19th century, Karl Marx saw firsthand the poor, deplorable condition of the working class. since the market economy was not able to provide for the working class, Karl Marx was in favor of abolition of this system, market economy, invisible hand, completely. Then in the 1930s, John Maynard Keynes, he proposed a solution for this problem. The market can provide prosperity if the state establishes a right framework. In the event of crisis and problems, the state must intervene. That means, according to John Keynes, there must be a coordinated market economy. And this is the idea behind the economic policy of any social democracy. The economic policy of social democracy is built on three principles. Number one is growth. Number two is social balance. And number three is sustainability. The growth should ensure enough wealth is generated to match the needs of the entire system. And this establishes the material foundation for good quality of life. That's why in that spectrum you saw social democracy was very close to capitalist system. But it's important that this wealth is not in hands of just few people, but for the whole society. This is the principle of social balance. This means, for example, the good work should be paid appropriately. So there should be high minimum wage. A sustainable economy is necessary in order to ensure that society in the future also have access to resources they need. Sustainability, you understand, it means that we consume as much as is replenished. So the three economic principles of growth, social balance, and sustainability each affect one another. There have been many political movements around the world, but they focus just on one or the two principles. What's special about the economic policy of social democracy is that it aims to have a balance among all these three principles. This is another article from the text and the context section that will take up the significance of Ethereum's merge for the future of cryptocurrencies. The consensus mechanism of Ethereum, this has changed recently. They have changed from proof of work to proof of stake. Before we get into this, what is this change? I'll quickly give you the basic of blockchain. Blockchain is simplistically a database, a series of information. It keeps growing as a series. Data packet A will get connected to B and C and D and E like this. It will keep on growing. It is a series of information, but it is not centrally hosted anywhere. It is distributed. That means copies of entire series of information, the block. One piece of information, the detail of any transaction, they are put in a block. This block will have various information in it. Information regarding transaction, the intrinsic information that has to be kept. But apart from that, it will also have other information as to which block is preceding to this in the series and which block is succeeding to this in series, information like that. So it becomes a chain of block, and hence the name blockchain. So it is chain of blocks of information which is distributed, meaning multiple copies of the blockchain is stored on multiple computers simultaneously syncing with each other. The biggest advantage of using blockchain mechanism for storage of information is that it is tamper evident, meaning if any tampering will happen, then the system will show that something has changed. And what has changed, when it has changed, everything can be verified because there are multiple blockchains on multiple computers. That's why. The reason why it is tamper evident is basically whenever any change has to be done in this block of information, in this chain of blocks, there has to be a consensus developed among the users. More than 50% of the users must accept the change. So more than 50% of users must validate that a change has happened, the transaction is legit. So suppose you go to this block and change this. This block was having, for suppose, the information regarding any land transaction. So when the transaction of land has happened, it has gone into new hands, then the information of the new owner has to be stored in this block. So one can change the information oneself, but then for that change to be accepted by the entire system, more than 50% of the users in this blockchain must accept the change. Meaning, simplistically, what it means is that more than 50% of people must verify the information of this block with regard to the previous arrangements. And if everything seems okay, then they will give the go ahead. And then only any information in the entire block will change. The reason why blockchain is so secure is because it is tamper evident and it is immutable. If any change has happened, it will be permanently recorded in the system because there are multiple copies. For some, there will be crores and crores of copies of it. So you change somewhere, and if that change was accepted, then it will remain as copies in thousands and thousands of computers. So at latter stage, you cannot simply come back and change it because the original copies will be in thousands. So that's how it kind of works. Because it is tamper evident and immutable, so it can be used in very sensitive processes like election. It can be used in financial transactions to track black money. It has enormous amount of application. Every block that we have been talking about, it will have various information in it. Every block will have a hash of previous block. So you know the exact sequence in which the information is getting added. Similarly, the blocks will also have the hash of the subsequent block, except for the last one. Whenever any transaction happens, review of that transaction happens in the peer-to-peer network. And for the transaction, that change to be accepted, consensus has to be built in the network. More than 50% of the user must validate that. Once the validation happens, then the chain gets extended. The additional block gets added. Now the problem is that it was so designed that for every piece of information to be changed, more than 50% of people has to do that verification. So for even one transfer of Bitcoin, and imagine how many people will be having that blockchain. Thousands, sometimes crores of computers will get involved in that process of transfer of just one Bitcoin. So the energy consumption is enormously high. It is inherent in the system. Presently, the way it has been working, it cannot work without consuming energy because the safety mechanism has been designed for peer-to-peer review. The energy consumption is so high that the total energy consumed by Bitcoins is more than Finland. The carbon footprint of Bitcoin alone is comparable to Switzerland. There has been shut down, complete crackdown on Bitcoin miners in Iran, in China. So there was pessimism with regard to future of Bitcoins and other cryptocurrencies. So what Ethereum has done, they have moved away from this mechanism of peer-to-peer review, which was earlier called as proof of work. Now what have devised a simple mechanism is of proof of a stake. Meaning at this stage where more than 50% of users have to give the consensus, now what would happen is system will randomly choose one or maybe few. And if they give their validation, then the process would be accepted. So many people does not have to get involved in each step of development of the blockchain. Now, since it will be randomly chosen users, so any kind of favoritism or collusion is statistically ruled out. But in turn, it will reduce the energy consumption by 99.95%. It will eliminate the need of so many computers to be active all the time. And yet it will maintain the security. But the step has been only recently taken. The success of shift from proof of work to proof of stake has to be validated in time. This is the article on page number 1. This is a developing issue, so we'll not discuss the whole issue at this stage. Supreme Court recently has referred the matter to the Constitutional Bench to decide on the question as to what meaningful time gap should exist between conviction and award of death penalty by trial judges. It has been observed that the day the conviction happens, the same day the death penalty is given. If you have been following news in the criminal cases, you would realize that first conviction happens and then the judges reserve the order as to what quantum of punishment will be given, and that happens after a week or so. Supreme Court earlier has ruled that death penalty should be given only in the rarest of the rare case. The issue of death penalty has been discussed previously in the DNS. I'll put up the link in the description section. If you want to brush up the topic, you can go to that link. When the Constitutional Bench of the Supreme Court passes the order on this issue, that day in the DNS will cover up this issue. That brings us to the end. Goodbye. Take care.